commercial property work exemptions. Now, this is based on a question we had from a long-term student, been around for ever and ever and ever, and love his questions when he comes through. So, and, you know, he works in the commercial space, in the large commercial and retail space, this particular agent. And he wanted some clarification about how he's working here. So that's great. And so we looked up the section of the Act that relates to this, and we had a good read of that. And then we looked at the information on fair trading, fabulous source of information here. So, and this has been around since 2016, I think August 2016. So 3 years now we've had this, and fair trading changed some of the legislation around this in terms of real estate agents dealing with certain commercial property agency work. So there's now some, that became 3 years ago, there are some exemptions. So the exemption applies if the agent is doing commercial property work on behalf of an affiliate of the agent. Now, what does that mean? That took us a little bit, and some clarification from fair trading, I must say, helped us out on this one in terms of what is an affiliate. And when you look at it, again, the information that's on the fair trading website, you know, an example is if a large commercial or retail shopping centre owns a property management arm and they are doing the property management for that, then they are allowed to do that as they are an affiliate of that property management company. So that's just saying that a large retail firm can own a property management arm to that, obviously fully licensed and done the right way. Now, the second part of it is where it actually affects people. And this is, the exemption applies if the agent is doing commercial agency work for an entity or joint entity or, you know, affiliate where that owns any property with an aggregate market value of $40 million or more. So she's a big one. Or an aggregate gross floor area of 20,000 square metres or more. So, you know, it's big in value or big in size in terms of the square meterage. So I guess in essence what they're saying is the people that are dealing with the properties, the retail properties that are this size and this value are big enough and ugly enough to look after themselves, and then it becomes not a commercial consumer issue. It becomes obviously it'll turn into legal and civil issues that these business people will deal with themselves. So, but I guess then the reality kicks in, and this is what we were talking about with this student that rang us up only yesterday, and it was, that's great. Some people only deal with that, and that means that they're exempt from actually holding a licence. They don't have to hold a licence. They're not bound by the, Property Stock and Business Agents Act. Obviously, there's lots of other legislation, particularly the competition consumer legislation around, what's misleading and deceptive, and the information that's given out. And so there's other legislation that covers that. But in terms of having to be licensed under the Property Stock and Business Agents Act, it's not required. However, the majority of agents that are dealing with these big ticket items or big sized retail premises, they're also dealing with smaller retail premises. So they've got to be licensed to deal with the smaller premises, whereas they don't need to be licensed for the larger, so they're going to have to hold a licence anyway. So if they're only doing the large, fine, they do not need to be licensed. If they're doing a combination of both, then yes, they're going to have to be licensed. So it's just that the requirements under the Act don't meet it. They are exempt for the purposes of those large properties, not for the small retail properties. So that's something good to remember about all of those.